We're going to start our discussion of Chapter 15, the federal court system, right now. And need you to keep a couple of things in mind as we move forward in this discussion of the court system. And the very first thing is that we are going to spend most of our time talking about the U.S. court systems, or what we call the federal court system. And we need to keep in mind in this chapter, more than any of the other chapters that we've talked about recently, that the United States is established under what we call a federal form of government. There are times when the state is sovereign, has ultimate authority over an issue, and there are times when the federal government is sovereign or has final say over an issue. And this is very obvious in the court system when we look at the fact that we actually have 51 different sovereign court systems in this country. We have one federal court system which deals with federal issues, and then each of the 50 states each have their own court system which is sovereign over their issues. There is not one policy dealing with voting that each of the 50 states has the same policy or the same law. Each state has a different law as it relates to each issue, voting, for example. So there are actually 51 different sovereign court systems. And if I've got an issue in my life that I think I need to take to the courts, the first thing I have to do is I have to figure out, is this issue going to be an issue that the federal courts will deal with, or will it be an issue that my individual state court deals with? Most of the time in this chapter we're going to be talking about the federal court system, but we will from time to time compare the two systems and show you if there are any significant differences on how they operate. The state court systems in our country are actually older than our federal court system, because if you think back to the first form of government that we had in the United States under the Articles of Confederation, there was no federal judiciary. Each state had its own court, and each state took care of its own issues. There was not a federal court system. You also need to realize that today, about 99% of all cases that are heard in this country are heard at the state level, and most of those cases stay at the state level. If I am accused of a state crime, even if I appeal my conviction of that state crime, my case is most likely going to stay within the state court system. Now, there is an opportunity in certain circumstances for my case that starts at a state level to carry over into the federal court system, but that's a very unusual situation for that to happen. Most cases start in the state court system and stay in the state court system. The last thing I want you to realize about the state court systems is that most state court systems use a very similar structure to that of the federal government's court system. The federal court system basically has three levels: the trial courts, the Court of Appeals, and the Court of Last Resort, or the U.S. Supreme Court. Most of the states use the same three-tier system. They have a trial court, an appeals court, and then courts of last resort, which most states call their state Supreme Court. There are a very small number of states who use a two-tier system. You go from the trial court systems to the court of last resort. They eliminate that appeals court. Really what happens is your court of last resort will act as both the appeals court and the court of last resort. The states that use that two-tier system are primarily your smaller states, where there is a significantly smaller number of court cases. The next issue I'd like to talk about when it comes to the American judiciary or the American court system is what the primary goal of our court system is. Many times when we watch the news, watch 48 Hours or some show that talks about some high-profile court case or some high-profile murder, people walk away from that show saying, well, that's unfair. We knew that guy committed the murder. Why isn't he in jail? Or that guy shouldn't have been in jail. Obviously, there was not enough evidence to show that he should have been in jail. When we walk away from a television show or a situation like that, we need to go back to what is considered the primary goal of our court system. And a lot of people believe that the primary goal of our court system is to determine guilt or innocence. But the problem with that is any system that is based on human structure is going to be fallible. There's going to be the opportunities for mistakes. So there's no way that a court system created by human beings can prove with 100% assurance in every situation that a person is guilty or innocent. In our system, there are times when the guilty go free and the innocent go to jail. Now, I'm not saying that's acceptable, but that should be understandable. For example, if I'm in the middle of the woods and I kill my wife and there's nobody else around but me and my wife, and now my wife is dead, there's no way for you to prove with 100% assurity in most cases that I killed my wife. So rather than say that our court system is based on determining guilt or innocence, a lot of people say, well, our court system is based on justice. Our court system should be providing justice. And there's a bit of a problem to say that we have a system that is based on justice as well, because if I was to murder somebody and you were to talk to the family of the person I murdered and ask them what would be a just punishment for me, that family would probably say the death penalty, or maybe even life in prison without the chance of parole. But if you were to talk to people who loved me, my wife, my family, they might believe, and truly deep down believe, that a just punishment for me would to be in jail for the rest of my life instead of the death penalty, or maybe I should be eligible for parole after 40 years or something. So to say that our court system is based on justice is a problem, because we have a very difficult time agreeing in every situation what is just and what is not. So when we look at our court system, legal experts will tell you that the primary goal of our court system is to try to ensure that everybody is treated the same, that everybody gets equal treatment under the law. And we've talked about this in the past. Basically what we're saying here is that our court system should be set up in a way that we do the best as possible to ensure that everybody is provided due process. The 17 steps in the process from when a person is accused of a crime to when they are convicted or found innocent of a crime. Due process means that every person that enters our court system will be given the opportunity to have every one of those 17 steps applied to them in a similar manner. It is sometimes difficult to swallow this or to believe this or put trust in our system when we have situations where some people who appear to be very, very guilty are set free. But we must go back to the beginning of this conversation where I said our court system isn't about proving guilt or innocence. It's about providing due process. Everybody in this country is innocent until proven guilty. How do you prove them guilty? You provide them with due process. And what will happen is, at the end of the system, at the end of the process, what will happen is if everybody is given due process, the vast majority of the people that are guilty will be found guilty, and the vast majority of the people that are innocent will be found innocent. And there's a lot of people who look at our court system and say, yes, we make some mistakes. We probably make more mistakes than we should. But when we look at our court system is biased in favor of the person that's on trial. And that's primarily because we would rather let a guilty person go free than let an innocent person be punished for something they did not do. Now keep in mind what due process means. We talked about this before, but real quick review of due process. It just simply means that the laws will be applied to the same to each person. And I have to be careful to say that the laws or processes of our country will be applied completely equally. Due process doesn't always mean complete equal. Due process means there are 17 steps in the process from being accused to having yourself found innocent or guilty. Every single individual in the court system will have the opportunity to have every one of those 17 steps applied to them. I, as a defendant, can skip some of those steps if I want to. When it comes to certain steps in the process, like bail, some people are going to be able to afford bail because they're more wealthy, and some people aren't going to be able to afford bail. Some people are going to be able to afford to hire a really good, high-profile, high-cost attorney. Some people that don't have a lot of money are going to be given an attorney that's paid for by the state. So we're not talking about due process being absolutely equal. But what due process also means is that even after a person is convicted of a crime, they still have the right to appeal that conviction. So if I'm convicted of murder and I believe that my due process rights have been violated, I am sent to jail because I'm convicted of that murder. But the due process of my situation continues. I can continue to say while I'm in jail that I think something was done wrong in the way that the law was applied to me. And if I appeal my conviction and some court somewhere down the line agrees that my due process was violated, then I could be given another chance to prove my innocence. I could be innocent. I could be given another trial. Most of the time when a person is appealing their conviction, they're not appealing their conviction based on the fact that I'm innocent because the jury in the court has already determined that I'm guilty. What the individual is appealing is that there is some procedural matter that was not done properly. My due process was violated. And we'll talk in detail about this when we get into the next section. Next topic I'd like to talk about concerning the court system in the United States is that there are actually two different types of law that the courts in our country will deal with. And the two basic types of law that we find in the United States is criminal law and civil law. So we have a series of criminal courts and we have a series of civil courts. And what I'd like to do right now is talk about the difference between the two types. And the first thing that we need to realize when we talk about the laws in our country is laws are not necessarily written as punitive things. We don't write laws just so that we can punish people for doing things that are wrong. We write laws to regulate the relationships between people. We write laws so that we know how we're supposed to treat others. We write these laws so we know how we're supposed to act in certain circumstances. So when we talk about criminal law versus civil law, we're really talking about the regulation of two different types of relationships. When we talk about criminal law, we're talking about laws that regulate the relationship between an individual and his or her society or community. When we talk about criminal law, when I commit a crime, I have done something that has harmed my society or my community. And when you have a situation where I have done something that has harmed the society or my community, the government of that society or the government of that community is going to be the one who acts as prosecutor, or they're going to represent the whole community or the whole society when attempting to punish me for something that I've done to violate the trust between me as an individual and my society or my community. Some examples of criminal laws would be murder, robbery, drunken disorderly conduct. Things of that nature are criminal law violations. And that's because when I murder somebody, I have violated the trust that the community has. When I have murdered somebody, I've taken somebody out of society. I've removed from that community or from that society the things that that person would have provided. Now, murdering somebody is also a very personal relationship. I've done something to that individual, but under criminal law, when I kill somebody, it's called murder because I'm being convicted or being accused of having violated some societal or some community trust. If I break into somebody's home, yes, it's a very private thing. But if I'm charged with the crime of burglary, I am being charged with making my community or my society less safe. I am being charged with making the members of my community or my society feel less safe in their neighborhood. So criminal law regulates the relationship between me as an individual or you as an individual and our society. When I'm charged with a crime under criminal law, it's going to be the government that will prosecute me on behalf of the society. That's why when you see criminal court cases, it's usually Sexton versus the state of North Carolina or Jones versus the city of Cape Girardeau. There's a government entity involved in that relationship. The second type of law that we have that we've talked about is civil law. And civil law regulates the relationships between individuals. For example, if my neighbor's dog was to break loose from its chain and run over into my yard and maul my chihuahua to death, I can't charge the dog with a crime. I'm probably not going to charge the owner with a crime. I'm going to sue the owner because the owner had caused damage to my property. So it's me, Kevin Sexton, suing my neighbor, John Lithgow, or whoever it happens to be. In a civil case, both sides of the case are individuals. The government is not directly involved other than generally the government or the judge will be a representative of the government. But in a civil case, it's usually an individual suing an individual. It could also be an individual suing a group of individuals, like I could sue IBM or I could sue, Merck, the producer of certain drugs. But that company that I'm suing, IBM or Merck, is a company that's owned by private individuals. In a civil case, it's usually not the individual versus the government. Now, you got to understand, let's go back to my example that I give about me murdering somebody. Now, me murdering somebody is a crime, and I'm going to be charged under criminal law. But when I take somebody's life, that's a very personal thing. So if I murder somebody, I can be charged with murder, the crime. But I also can be sued by that person's family under civil law. Because by taking that person's life, I have violated both criminal law, the murder, but I've also, done something personal to the member of their family. So I can be charged for violating both criminal law and civil law. Now, another major difference between criminal and civil law is what we call the standards of evidence. In order for me to be found guilty of a crime, you have to have evidence. You have to have enough evidence to show that I'm guilty. For me to be found negligent under a civil case, the same thing. There has to be a certain amount of evidence. Generally, when we talk about criminal cases, we talk about people being guilty. When we talk about civil cases, we generally talk about people being responsible or negligent. Very rarely will we hear the word guilty used in a civil case. Now, there are different standards of evidence. There's a different amount of evidence needed to prove that I committed a crime as opposed to show that I was negligent in a civil case. And those standards of evidence in a criminal case, guilt must be proven beyond a reasonable doubt. And if we were going to be using, mathematical equations or percentages here, in a criminal case, you have to prove with almost complete certainty that I committed the crime. I would say, 98.9 or 99% sure that I committed the crime. The phrase beyond a reasonable doubt means that if a reasonable person can look at the facts of my case and believe that somebody else could have done it, that I am supposed to be found innocent. It's very difficult to prove guilt beyond a reasonable doubt. Now, in a civil case, responsibility must be proven beyond a preponderance of the evidence. And basically what that means is there simply has to be more evidence that I did it than I did not. And if we're going to use, again, a percentage here, in a civil case, only 50.1% of the evidence has to show that I probably did it. If less than 50% of the evidence shows I didn't do it, then I'm supposed to be found not responsible. But if there's one more piece of evidence showing that I probably did it, then I didn't do it, then I'm supposed to be found responsible. Major differences in the standard of evidence for a criminal case and a civil case. And there is a major reason for that difference. And the primary reason that there's such a difference is if I'm found guilty in a criminal case, I could be facing extended period of time in prison, or at the very worst, I could be put to death. So if I'm going to spend a lot of time in prison, you're going to take all of that time away from me. You want to pretty much make sure that I'm guilty. Because if I'm in jail for 45 years and it turns out I wasn't guilty, you can't give me those 45 years back. Or if I am put to death, and then after I'm put to death, it's determined that I wasn't guilty, you can't give me my life back. That's why in a criminal case, you have to have such a huge amount of evidence. Whereas in a civil case, the most I'm probably going to get if I'm found responsible in a civil case is some fines. I'm going to be told I have to pay, the family of the person I'm accused of killing, $100 million or $2 million or something. And if I pay this family $2 million, and then 10 years later you figure out that I didn't have anything to do with that person's death, it's much easier to give me that $2 million back. So there's a huge difference between the standard of evidence in a criminal case than the standard of evidence in a civil case. And the final thing that I want to discuss when it comes to our court system is this concept that we are all aware of double jeopardy. Double jeopardy basically means that I can't be tried twice for the same crime. The Fifth Amendment reads, "Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb." But what that means is I cannot be prosecuted more than once for violating the same law with the same action. If I take a knife in my hand and I stab somebody in the heart, I'm charged with murder, If I'm found not guilty of murdering that person, you can never come back and charge me with murdering that person for that action again. Once I'm found not guilty, you can't come back and charge me with that crime again. It does not mean that I cannot be charged twice for the same action if one action violates more than one law or more than one type of law. If I was to stab somebody in the heart and be found not guilty of murder, the family could then come along and accuse me of a civil law violation. And if the civil court finds me responsible for their death, then I would probably have to pay a fine for causing their death, but I would not be put in jail because I was found not guilty of the crime of murder. Let me give you, everybody remembers Timothy McVeigh back in the mid-90s. He was convicted of blowing up the federal courthouse in Oklahoma City. He was tried by the federal government and sentenced to death. He was also tried for blowing up the courthouse by the state of Oklahoma. Now, this would not be considered double jeopardy. It would not violate the Fifth Amendment because in the first case, Timothy McVeigh was accused of violating federal law and found guilty. Then the state of Oklahoma came along and said, you also violated Oklahoma law. Remember, there are 51 sovereign court systems in this country. The federal government is one, and the state of Oklahoma is one. Timothy McVeigh pushed the detonator on that bomb and blew up the courthouse. By pushing that detonator one time, he violated federal law when he killed and harmed federal employees in that building, but he also violated state law when he killed state employees in that building. So that would not be an example of Timothy McVeigh's double jeopardy rights being violated. Another example is O.J. Simpson. O.J. Simpson was found not guilty of murdering his ex-wife, which is a crime. He was found not guilty of the crime of murder, but he was later found negligent in her death, which was in a civil case. He was tried twice for the same action. Let's assume that he cut her throat with a knife. He was tried twice. Once they said, did that action of him holding the knife and slitting her throat cause her murder? Was it considered murder? No, it wasn't. He was found innocent of murder. But what they found was that there was so much evidence that showed he probably killed her that he was determined to be responsible for her death. He was found not guilty of the crime of murder, but he was found negligent of the civil violation of wrongful death. The next videos that we're going to watch dealing with the court system will deal specifically with the way that the federal system operates, keeping in mind all of these things that we've talked about: civil law, criminal law, double jeopardy. All of those things apply pretty much the same way at the federal court system and at the state court level.